Mr. Stuart Baggish is here. Many of you know him because he has been a speaker for several years. I'm sorry, I don't have my phone with my bio on there, but you all probably know that Stuart Baggish is an attorney in the city of Austin. He's also throughout the, Florida. Where are you?
California.
Licensed in, yes, Florida, California, and Texas. He could probably tell you about his obscenity case that he represented. There's actually a movie on IMDb. If you search for Stuart's name, it'll pop up. But he has quite a following when it comes to law, constitutional, and he can also tell you about being in the classroom. Some of the topics that came up earlier, teachers are worried. Can I do this? Can I say that? Stuart will let you know. He also has a wealth of information on what recourse you have as a teacher, how you can file complaints, how you can get your case heard. But you have to know the hacks. You have to know, what papers to fill out, what forms to fill out, and Stuart can help you with that. So Stuart, if you want to come on up.
What I want to talk with you about today is fighting evil in Texas K through 12 public schools. I've got here, for those of you who can't read, it's one of my favorite lines of scripture, which is Matthew 18:6. It says, if anyone causes one of these little ones, those who believe in me, to stumble, it would be better for them to have a large millstone hung around their neck and to be drowned in the depths of the sea. That's to set the tone of what you're going to be dealing with. We're in a culture in the United States right now, and y'all are on the front lines of it. There are a number of fronts, and education is one of the most important that there are. And it is a fight between good and evil. What we're talking about today is how educators can push back legally on some of the evil that is taking place in K through 12 public schools. Now, there was a question that was submitted before today's conference, and that question was asked, how can I speak up against those who are tearing down biblical principles in class? Well, there's a variety of ways. We have momentum on our side, because SB 10, Senate Bill 10 from the 89th legislature, which is now law, requires posting the 10 commandments in the classroom, and that means you're no longer relegated to a vacuum. When other educators tear down biblical principles in class, you should point out to them that they are being intolerantly Christophobic, and use that term. That is a term that they need to have on the tip of their tongue just as much as the term transphobic or Islamophobic is on the tip of their tongue every time somebody bellyaches about something. They should be worried about being accused of Christophobia. And we need to popularize that term. And how do we do that? By repetition. They hear it so often that it just becomes part of everyone's vocabulary going forward, and it comes to be accepted. There is such a thing. If you want history, we've got tons of it, and it goes back more than 1,000 years. So we point out that they're being intolerantly Christophobic. 2, tell them that they are creating a hostile work environment. That's a key phrase. Why? Because it's mentioned throughout civil rights litigation. It's you can't, as an employer, create a hostile work environment for your employees without being subject to what? Litigation for what? Discrimination. And what's the last thing that a school district wants to have to deal with? An accusation of being, engaging in discrimination. So start that up, number 1. Number 2, and then follow up by filing a written complaint with the school district to that effect. We're going to say most teachers will back off after an administrator comes to interview them about it. So take the offense. Now, when you see a book in the library, another thing that you can do, a hack, when you see a book in the library that's no good, you can grab it and drop it between the stacks so nobody will be able to get to it, or just turn it around so that the spine isn't facing out anymore. Oops. Wait. I'm going backwards, actually. Okay, now I've got the right order. Number 2, how do we access the Bible curriculum to be implemented in public schools? Also, any resources would be helpful. You know, keep an eye on the TEA website for curriculum updates. In the meantime, you can use your own materials. You can bring whatever you want into the classroom so long as you can connect it to history. Don't bring in something totally ahistoric. That you're going to lose on. But so long as you can connect it to history, you're allowed to use it. I'm not an expert on finding curricular aids, but I can recommend a particular organization called Wall Builders, which is in Aledo, Texas, run by David Barton. And they are very well informed and oriented to help you substantiate with evidence from the founding fathers themselves that America was founded as a Christian nation. For instance, this quote from John Adams in 11 October 1798 said, "Our Constitution was made for a moral and religious people. It is wholly inadequate to the government of any other." Well, that's not ambiguous. That's not something that requires interpretation. That's a positive assertion of fact, and those are the actual words. And the good thing about David Barton is, for a lot of these documents that are referenced, he has the originals. He has one of the largest libraries of authentic primary sources of the founding fathers of the United States. So look up Wall Builders and give them a holler. They probably have posters and things that you can put up. And he'll get you going in the right direction. I'm sure there's other providers who can help you. Question 3, can I start a prayer group at work, or can I have a Bible verse displayed in my office? Yes, you can. You can start a prayer group at work. If the administration interferes with it, do some digging. Find out if they have treated other groups this way. For example, the Muslim Students Association. Did they allow them to speak? Did they give them access to the facilities, the auditorium, the conference room, whatever? Whatever they have provided to the Muslim Students Association, they have to provide to the Christian students. They have to provide the same access, the same facilities, the same time. If they gave the Muslim Students Association access to the conference room at 3 o'clock in the afternoon, guess what them telling you you get it Saturday at 6 in the morning is inadequate. They can't pick and choose. It's all or nothing. Once the door is open, it's open. Now keep in mind, if there are no other religious groups on campus, or once you gain access at the school, you will be opening the door for others. Hopefully that's not a big problem, but you know, in some districts it is a problem because you've got not just Muslims, but also Satanists and witches as well, who want their equal time. And they will get it. They will get it. You know, the administration cannot require you to remove a cross from your desk, a Bible verse from your workspace, or make you conceal your cross necklace under your garments, unless the dress code requires it of all people. So if they're going to say, you know, that cross has to go inside your sweater, well, ascertain, do they in fact have a rule that prohibits all necklace pendants? If they don't, if they're picking only to go after your cross, That's what's called content-based discrimination. You're not allowed to do that. That's a First Amendment violation. They can prohibit all, necklace pendants, but they better enforce that across the board equally without regard to what the pendant is. Now, you may be subject to discipline if you go down this road. You may end up getting written up because your cross pendant is visible instead of tucked inside your sweater. But that's fine, because that's going to make your case stronger when it comes time. The whole point of all of this is you want to proceed to a point where you can take your case to a judicial court and get out of the school district where everything is going to be stacked against you. In order to get to the judicial courts, you have to satisfy some prerequisites. You have to do what's called exhausting administrative remedies. That means filing a complaint with the district in a timely fashion. Keep a lookout, because they have absurdly short deadlines in civil law and in criminal law. Everybody is familiar with the ideas of periods of limitation, the statute of limitation. You hear that a lot on TV shows. Oh, the statute of limitation has expired. Well, school districts have the shortest periods of limitations of anyone I've ever seen in 36 years as an attorney. And they have time limits in some districts where if you don't file a complaint within 3 days, and it's got to be in writing, you don't file it within 3 days, you're timed out. And then once the district makes its decision, you file the complaint, 73 hours after the event on which the complaint is based. You file a complaint, they deem it untimely, it's denied. You've now got, in some districts again, you've got 5 days to appeal the thing. Now, don't be intimidated by the fact that you have to do a written complaint. That doesn't mean you have to file it on pleading paper with a proper caption and everything. All it requires is that it be submitted in writing as opposed to orally. So you can do it by email. Do it to somebody who is an officer or a representative of the school district. Well, in the school, who's that going to be? The guys in the front office, the admin folks, the principals, the assistant principals will do it. It does not have to be sent to the general counsel of the district. It does not have to be sent to the superintendent. If you copy them, belt and suspenders, you're better off. But be mindful of the time limits that have to be complied with, because here's the thing. If you do not exhaust your administrative remedies, every single court will dismiss your complaint in both state and federal. So you have to exhaust administrative remedies before you can proceed in judicial court, because there's the government. You're dealing with a claim against the government. So you've got to first go to the government that's offending you to see if they will straighten up. Now, question 4. After 5 years of the parent, any advice? Yeah, you're going to start off your classes differently this year. Hi, I'm blank. Nice to meet you. I'll be teaching you blank, and we will be studying the Bible in this class. Yay, that's your first day of class. Yay, I'm super excited about it, and hope you will be too. The Bible is the foundation of our great American Republic, and you need to understand what it contains in order to understand what America actually is. That's the core, right there. You don't understand anything about America unless you understand that. It's a founding principle. Now, a lot of folks are thinking, is this what's going to overcome my opposition? Am I going to be able to beat them down? Will they surrender if I read that to them? No, they're not. They're going to keep fighting. You know why? Because it's inherent. That's what they do. As soon as one issue is resolved, there's another one. There's always something about which to start trouble, isn't there? The conflict never ends. It's Sisyphus pushing the rock up the hill, and it never ends. But you know, we know to expect that. And why is that? Because salvation comes through faith. If it's all going to be determined by logic, well, that doesn't require faith, does it? We're going to be fighting this, so let's be happy warriors, and we'll stay on the good side of things. And we're going to do that in the classroom. One of the things that I saw on, this is from, I'm sure you can't see it because it's at the very bottom right here. That says July 22nd, 2026. So this was only 10 days ago. Somebody wrote on social media, state helps trans teen disappear. Family awaits SCOTUS to stop kidnapping of child. And then Citizen Go USA commented, in my day, we were warned about white vans and offers for free candy. Now parents are being tricked into sending their children right into the arms of kidnappers, disguised as educators. So teachers are doing this. The teachers are kidnappers. This is topsy-turvy. This is one of the indicators that we're getting near the conclusion, shall we say. Things are coming to resolution. Things are manifesting. Up is down, left is right. You read through the entirety of Supreme Court jurisprudence on the subject of education law up until a turning point in the late 90s, early 2000s, the concern was always about protecting the welfare of the child, not about hauling them off and getting them hooked on exogenous hormones for the rest of their life and walking around with bodily wounds that never heal. And that's what they're doing. And over parents' objections, I mean, the schools are actually the tip of the spear that is being used to jam a lot of what is evil down society's throat. Why? Because the schools have billions of dollars. It's a major segment of our economy. I don't know if you've noticed that every commercial on television is now for, some type of a pharmaceutical. Well, that's the pharma industry, and that's probably the biggest healthcare when you combine it with hospitals and medicine. But number two is education. And people who have that kind of money, if they want to do ill, they accomplish it. So we're constantly pushing back. Now, taking K through 12 public school district minor students who are not your own children off campus without parental permission is kidnapping. You can't do it. You take kids to No Kids Rally, you had better have a written permission slip from the child's parent authorizing you to do that, because if not, you have just kidnapped that child. Minor students are at public school to learn mastery of the TEKS, not for political radicalization. In the Mahmood versus Taylor case, SCOTUS recognized that parents have a fundamental right to oversee the upbringing and education of their minor children. Well, what does that mean? It means that for any action that the school district seeks to take, they will only prevail if they're opposing your efforts to exercise your rights to communicate in biblical terms on campus during school hours in the presence of students. If they are interfering with it, the parent's decision about the upbringing of their child has been recognized as a fundamental right, not just a right. It's not like a driver's license. It's not, it's a fundamental right, and that means that for anything coming before a court or a decision maker, like a school board, they are presumed to be invalid, the district, unless they can show that their actions against the parents serve a compelling district interest. Now, we're not talking about, mere blandishments like promoting diversity. A compelling interest is actual imminent life and death matter. The fire in the crowded theater situation. And not only does it require a compelling state interest, the actions by the district in order to be valid has to be narrowly tailored. What is that? That means that it doesn't infringe the parents' rights to oversee the upbringing of their own children any more than is absolutely necessary. If it goes 1 inch further, it's invalid. So that means not only is the school district's position going to be presumed to be invalid, you're going to be able to make a claim that the school board is going to have to decide. First, you're going to be filing a complaint with the school district. They're going to reject you. Then you're going to file an appeal with the school district, and they're going to reject that. That's exhaustion of the administrative remedies before the district. After that, it's off to the races. You're going to file your suit for religious discrimination in federal court. Under federal law, you're now going to have a Justice Department that isn't going to oppose you at it. In the past, they were. Under the current administration, they're actually in favor of it. Because under previous presidential administrations, half the battle was getting the administrative agencies to do what they're supposed to do. And they did. But things are getting dialed back into place. So the old way of doing things are over. Now I want to talk about, just very briefly, Texas Education Code Chapter 26 has the Parents' Bill of Rights, and there's the example that's highlighted there. That's the actual text of Texas Education Code Section 26.010, which is exemption from instruction. And that's the law on which all the opposition to the mandatory LGBTQ plus stuff is based. Not only are you not required to allow your kids to be subjected to the LGBTQ plus instruction, and they are going to try to push it because they know if they can't do it by one avenue, another is how the approach is. They're wily. There is this section of 26.008, which provides that any attempt by a school district employee to encourage or coerce a child to withhold information from the child's parent about what the instruction is or what the clubs are, that's grounds for discipline. And it no longer says just a teacher. It's now any district employee. What does that mean? That means the librarians are on the hook. A lot of librarians are not SBEC certified, so they were never bound to comply with the Educator's Code of Ethics. That was a big gap, and the left took advantage of that. That's why so much of what was being done, this radical push for Marxism in the schools, it was being done by the librarians. The librarians have associations of their own, but they don't contain mandatory, mandatory codes like the Educators Code of Ethics in Texas does, something that you've got to comply with at all times in all places. That can expose, your teaching certificate, and the librarians, a lot of them don't have a certificate of anything. But this is a great thing. Oops. Now, HB 4623 is fantastic. It waives sovereign immunity. It's now Chapter 118 of the Texas Civil Practice and Remedies Code, and it provides for a cause of action against the school district or open enrollment charter school for sexual misconduct against students. Used to be for kids who were victimized by school personnel that they raised a concern, but they couldn't go into court. Why? Because of the doctrine of sovereign immunity, and the Texas Tort Claims Act didn't waive suits against school districts, or didn't waive liability prohibiting complaints against school districts for sexual abuse. It, provided waiver of immunity for, damages arising from the operation of a school bus, but not sexual abuse. This has now changed. HB 4623 provides that a public school is liable if it's grossly negligent or reckless, or engages in intentional misconduct in hiring, supervising, or employing a professional school employee, and that employee commits against an enrolled student sexual misconduct, which includes rape, sexual abuse, improper educator-student relationships, and related misconduct, or failure to report suspected child abuse or neglect. So now the school district is on the hook. And these cases have massive damages because children's lives are destroyed, and in a lawsuit where you're calculating damages, the most listened to witness in the course of the trial is the economist who comes in to testify about future earnings that have been lost. Well, you're talking about somebody who's in their teens. Their future earnings go on and on, 70, 80 years. And how do you attach a dollar value to a kid who, instead of being on the track to be a physician, she's now a prostitute living out of a trailer in San Diego because of the way things went here. It's massive. You're talking about damage potential in tens of millions of dollars. That's going to get the attention of school districts. So they're going to start paying attention and cracking down on some of this stuff, because for a very, very long time they were hiding behind the sovereign immunity, and finally that has been ripped away, and that's a very good thing. Am I running out of time? Where am I on time?
You have about 5 minutes.
Okay, I'm gonna put a bookmark in it because I want to make myself available to answer questions for y'all. What questions, if any, can I help you with? I'm happy to go on. Okay.
It says free legal advice right here. This is your opportunity.
What about requiring librarians to subscribe to the teacher's code of ethics?
Well, it's a great thing, and it should be done with the rules as they currently exist. The only way to do that is to require that the librarians have an aspect certificate. But their voluntary subscription to, yes, I'll be bound in an employment agreement, that's great for purposes of getting rid of the librarian for when they violate it. Well, all that means is you can terminate them without, being sued for doing so. And also the district is wary of terminating, positions that they don't have somebody immediately available to fill the spot. They like to know, and they like it to be, in May, not in January, when the termination is made. But yeah, you can do it. That will probably, from psychosocial perspective, weigh on the librarian's mind to lead the librarian to conform to the educator's code of ethics. But truth be told, there are going to be some librarians who just don't care, who won't even bother to read what the educator's code of ethics provides. I was shocked to find out that most educators aren't even aware there is an educator's code of ethics. And it's 19 Texas Administrative Code section 247.2. Look it up. If you haven't read it before, you need to know it, because it's the rules of the road, and it's got to be followed at all times, in all places. You're on vacation in Thailand. Guess what? If you are involved sexually with a minor while you're over there, you can still lose your Texas teaching certificate because of it. By the way, I didn't pick Thailand at random. There's a lot of educators who go on vacation to Thailand. And it's not to see the temples of Angkor Wat.
Any other questions?
Oops. Any questions? Okay.
I have a question.
What's that?
If I can. I have been personally very concerned about the inappropriate sexually explicit content in our school libraries. Let's say, for example, a teacher is in the classroom or counselor, and they overhear students talking about this book, and the students are talking about how hugely inappropriate it is, and the teacher feels the moral obligation to do something about it. Feels like this is not okay to have this book in the school. Balancing, do I want to lose my job over this? Is it worth it? It just feels like internally compelled, like I've got to do something about it. So what is a teacher supposed to do? Let's say the book is All Boys Aren't Blue. Look in your libraries, it's there. It is horrific. It's probably in all of your schools. What is a teacher to do? How far do they have to take this in order to actually have some sort of resolution?
Well, are you talking about it's in the school library, or it's in a personal individual
Let's say
classroom?
in a school library.
Because different things.
Yes.
If you go into a particular teacher's classroom and you start monkeying with her books, she's going to know as soon as she walks in the room, she's probably going to know who's responsible for it. So the chances for it, for repercussion is very high for being identified. If it's in the classroom, wouldn't recommend anybody, commit any acts of theft. That's unlawful. It will also result in a termination being upheld for stealing government property.
So don't steal a book.
But it doesn't have to be right at everyone's fingertips. If it's between the stacks,
Right. Hide the book.
who's even to notice that it exists anymore? I mean, it's kind of like Schrodinger's cat at that point.
So beyond hiding the book, I know, but what can we do?
And if you don't want to do that because, it would be too obvious, it's going to make a clatter, kind of like a kettle drum when you do it, just turn the book around.
But legally, or policy.
Those are legal. You're not taking the book.
I know.
You're leaving it in place. You're limiting its circulation as far as what you can do legally with bringing a complaint. If the person who is responsible for putting it there on the shelf has an SBEC certificate, they are bound by the Educator's Code of Ethics, and Standard 3.9 of the Educator's Code of Ethics contains the requirement that it governs educator-student communications. You can't have sexually inappropriate communications with a student as an educator. You have to observe proper educator-student boundaries, and you have to be worthy to instruct the youth of Texas. That's another standard under the educator's code of ethics, the educator must be worthy to instruct, and that means morally upright. But if they are communicating in a sexually inappropriate way, well, most people think that means, well, that's just, sending emails or text messages. That's not all it means. When you hand a student a textbook, you're communicating its contents to the student. So if it contains graphic, sexually explicit material in it, like All Boys Aren't Blue or any number of other volumes, if the librarian has an aspect certificate, file a complaint against them, a written complaint with TEA. It needs to be in writing and it needs to be signed, otherwise they won't do anything with it. If it is in writing, signed, and you cite the relevant education law that has been violated, you're just going to write 19 TAC section 247.2, standard 3.9. That points them at the specific code requirement.
Will you email that to me so I can share it to
Yeah,
educators if
absolutely.
they're interested?
Yeah.
Because, not knowing the specifics about
Yes.
the law to be able to
Yeah, and
cite
all
that.
it takes is you do it in writing. TEA has a specific complaint form. The general complaint form is good enough to use, but it requires a signature. You can't do it anonymously. So,
Okay, I think I have one more question. I don't want to
Yeah.
take too much of
What
your time.
would you think about something as innocuous as a teacher who wasn't feeling well, sitting in their chair and ask a student to come tuck her in?
Is this a real life example, Kathy?
I just heard about this from
And
someone in here.
that's very peculiar.
That's weird. Yeah, that seems like touchy.
Yeah, I mean, it's grooming behavior.
Yes,
It's
what
laying
would you
the
do?
groundwork for worse things to come.
What could you
Highly
do?
reminiscent of Mary Kay Letourneau. Not sure if any of y'all even know who she was.
I like it.
But, yeah, pretty gross.
What would
Can
the
you file
person
a
do?
grievance? Sorry.
You can-
File a grievance, a formal complaint?
Oh, yeah. I mean, you can file a complaint over anything you want. The question is whether it's going to have teeth, whether you're going to accomplish anything by doing it. And the way to do that is to cite the law, give the facts that make clear that the law that you're citing has been violated, and give them, the date the violation occurred, where it happened, and who committed the violation. That's really all they need to go forward.
Can they take the word of a child because the parents aren't going to be in the room?
It's something that bears investigation, but the fact of the matter is, that's what you're talking about, is whether it's enough to start an investigation. And I would say yes. The fact of the matter is, wherever it leads, they're probably going to be finding something in that teacher's communications of her own that revealed something along the same lines of what was, it may not be the same student, but because these are creatures of habit.
Thank you.
Stuart, will you be here for a little while if somebody wants to run something by you?
Yeah.
Okay. Free of charge. I mean, this is your opportunity, so be thinking of your questions. Thank you, Stuart, for being here. We appreciate your